Well, hello and good morning. Welcome to another daily update regarding the California Board of Psychology hearings coming up on December 29th through 31st. If you're not paying attention to this, shame on you. If you're not trying to get media to observe this hearing, shame on you. If you're not trying to get your legislative representatives to wherever you are, Michigan or Florida or Texas, wherever, if you're not trying to get your state legislators to, or at least an assistant, an aide, to attend to this seminar or this hearing, shame on you again. This is going to be historic, I think, on multiple levels and of broad interest to a number of people. So we finished our oral arguments on some motions in Lemonade yesterday, and now we're prepared to move into the hearing. And so I'll be spending this week doing preparation for that, and it begins a week from this Monday. So let me talk about that a little bit here. So I get to cross-examine Doctors Berent and Lorandos. That is going to be the highlight. I get to cross-examine the two top self-proclaimed experts in parental alienation, likely Monday afternoon, although it may start Monday morning. And you will want to watch that. That's going to be a very interesting cross-examination. During that cross-examination, I intend to provide some emails to Doctors Berent and Lorandos relative to our communication, some direct emails we've had from 2011 when I first began interacting with Dr. Berent, to some emails from Dr. Berent to his parental alienation study group, of which I was a part in 2013 around the DSM-5 diagnosis and the release of that by the American Psychiatric Association, and that demonstrate his understanding that both the American Psychiatric Association had fully rejected the construct of parental alienation, and that he was fully aware of what the actual DSM-5 diagnoses were, and DSM-4 as well. So that will be interesting. And then an email exchange from 2022 that involved Doctors Berent and Lorandos contacting me, objecting to my criticism of them in a particular post, and I removed the post per their request, but I also provided them with my concerns directly. And so I'll get to cross-examine them about that. And so that should be very interesting. Plus, I've met with Dr. Berent twice, once in 2017 in Boston around the AFCC convention, witnessed by Dorsey Pruder, and then once in 2018 surrounding a conference in Venice, Italy, where I hosted a dinner for myself and my wife and Dr. Berent and his wife and Dorsey Pruder, who was over there, and as well as a parent advocate from Europe, Peter Knudsen. And so we met there, and Dorsey and Peter will both be testifying when the defense presents its case regarding the nature of the discussions that I had with Dr. Berent in 2017, but most prominently in 2018, the Venice dinner conversations. So that should be very interesting as well. And then I get to cross-examine Doctors Berent and Lorandos on their competence. Basically, they're seemingly going to assert that they're experts in parental alienation, and I'm going to examine them for basic competence with the pathology. And we're going to see what happens off of that. And so that should be very interesting. Theater, to Perry Mason kind of theater. Now, I'm in the courtroom. It's not theater to me, it's cross-examination of the PAS experts. And so you're going to want to watch that. There will be a transcript, but, there may be a few good men or, the Caine Mutiny kind of courtroom scenes going on. Who knows what's going to happen when the top experts in parental alienation are cross-examined by their top critic in Dr. Childress. That should be kind of interesting. So you'll want to watch that. But it's going to be historic in other ways as well. The two most prominent PA experts, Dr. Berent and Lorandos, are going to be cross-examined under oath with a court reporter present by the most vocal critic of PAS, Dr. Childress. This is going to be a historic event, but it's also going to be historic on several other domains. First, I'm in my defense, I will be seeking to introduce evidence related to institutional capture and institutional betrayal trauma. And that will become relevant in my direct testimony as I speak about my background in community clinical psychology and my analysis of the situation. Now, typically, each party presents their expert witness and their report in support of their particular position. And so the state will be presenting their expert witness and the report that they wrote up regarding my criticisms of Doctors Berent and Lorandos relative to the application of the collegiality standards. Now, the defense is arguing that there's a conflict of ethical obligations within the APA Ethics Code between the collegiality requirements, typically the 3 series, and the protective obligations, standards 1.04 and 1.05 that are triggered by ethical violations. And in this case, the ethical violations will be to 2.01 and 2.04, cascading out to 9.01 and 3.04. So during the cross-examination of Doctors Berent and Lorandos, we will be exploring the potential violations to standards 2.04, bases for scientific and professional judgments, and violation to standard 2.01, boundaries of competence, that would then trigger the protective standards of 1.04 and 1.05, which were discharged at Venice meetings and other places, as well as evidence of the harm, the 3.04 harm done by parental alienation and that approach to conceptualizing the pathology in the family courts. So that's going to be a very interesting cross-examination, kind of thing. But this is going to be historic in several other ways, from merely the cross-examination, because it's going to hopefully introduce evidence about the institutional capture and institutional betrayal, which I am expert in because I've had training as a master's degree in community clinical psychology, which is how community institutions and pathology interact and how they do that. So I'm kind of an expert in institutional regulatory capture and institutional betrayal trauma. And so I'll be hopefully introducing that, potentially over objections, during my direct examination. And so that's likely to be a historic event too, because the pathology, the abuse pathology, isolates its victims from reporting and rescue. And that's a classic feature of that. And that's exactly what's happened in the family courts. There's a specialized group of psychologists called forensic psychologists who have captured the families in the family courts and are preventing their rescue from clinical psychology and their reporting into clinical psychology of the abuse going on. So we'll be looking to break that out. But I'm not presenting an expert with an expert report, as is traditional in these hearings, and that kind of confused the state a little bit about the role of Dr. Strom when I consulted with him. He's not an expert witness with a report and an opinion, and they were kind of expecting, where's his expert report and opinion? And what I'll demonstrate at the opening of my direct testimony is I am the expert. Okay, there's nobody higher than Dr. Childress who could evaluate the situation. I am the expert because of my specialized expertise in a variety of relevant domains: attachment, delusional thought disorders, child abuse and complex trauma, uh, family court pathology, 15 years, Munchausen by proxy, factitious disorder imposed on another. I am the expert. I combine all of that, and there's nobody else that does that, plus the Belmont report and IRB review for experiments. So there's nobody to say, hey, come evaluate. I am the expert. So that's what I'll be presenting in my opening of my direct. But then on Wednesday as well, I'll be seeking to introduce some AI augmented analysis regarding a Malaysia consultation. And I relied on ChatGPT for that analysis, and I'll be seeking to introduce that as evidence of the harm that's caused by this parental alienation PA construct. And then I will be seeking to introduce a Claude analysis of the ChatGPT Malaysia consultation that looks specifically at the harm caused by Doctors Berent and Lorandos and their PAS model, which was cited by the court reform people in Malaysia. So they cite Dr. Berent to come up with their court reform proposal. They provide it to me for a consultation. I provide the consultation through ChatGPT 5. So it's I'm supervising the consultation. So you'll see that in the chat dialogue, technically called a prompt response log. So you'll see that in that Malaysia chat dialogue with the ChatGPT that I'm providing the supervision on that. And in all AI analysis, I'm responsible for it. I take authority for it. So I'll be seeking to introduce that. And then the Claude analysis as well, which is also conducted under my supervision. So I'm going to be seeking to introduce AI analysis into a legal proceeding, in this case, an administrative hearing in front of the Board of Psychology. That's likely the first time this is going to be argued in a legal proceeding, the admissibility of AI evidence. Now, I'm a psychologist in the family courts doing second opinion review, and I'm bringing AI into the analysis. So this won't be the first time, or this is the first time, but it won't be the last time, because AI is here, and it's changing all aspects of our culture and society. And so this is going to be an issue that the courts will need to address increasingly over the years as AI becomes better and better and it gets more integrated into our society. What is the role of AI analysis in court situations? And it's specifically applicable in the family courts where there's a he said, she said, and complex and the sides and things. AI is perfectly neutral and can review a massive amount of documents such as emails and texts and reports, and it's a large language model. It can look at them, look for patterns, ethical compliance or patterns in the communication regarding path A, abuse by the targeted parent, or path B, psychological abuse by the allied parent with a delusional disorder, factitious. And so it can look at all that and removes all the human argument, the staff splitting that comes from personal agendas. It's just nice and clean and neutral you can look at. Now, what about cross-examination, though, of that evidence? Well, the state I'm providing it to them. They can upload it to their own AI and talk about it. They can read it and analyze the AI analysis from ChatGPT and Claude. And then when they're cross-examining me, they can cross-examine me on those because I take authority for those chat dialogues. So they can ask me any question they want about that, and I will provide the cross-examination because the AI is just an AI. It doesn't operate separate from the supervision that the professional provides. So they can, but this is likely to be a very historic case in that regard as well, because on Wednesday, the administrative law judge will likely be put in a position of evaluating the admissibility of AI-related evidence in a proceeding. Okay, and conducted under the supervision of a licensed psychologist, at least currently licensed psychologist, and this will be an interesting precedent-setting, potentially, hearing that has global implications because it's coming from Malaysia, and Mr. Knudsen will be discussing the European extent of this pathology. That it's a global event because if the licensing board decides in the favor of Doctors Berent and Lorandos that they cannot be criticized or that the criticism has to be restrained and can't be about their ethical violations and the harm that causes, then that has global impact of locking in parental alienation again for another 20 years or whatever as the dominant paradigm. If Dr. Childress is not sanctioned because I'm operating under the protective standards of 1.04 and 1.05 and taking further action appropriate to the situation, then that changes the entire court landscape over to the DSM-5, shared delusional disorder and child psychological abuse, and we start getting clinical assessments for the child abuse and spousal abuse. Takes 6 to 9 weeks, $2,500, can get second opinions on them. The whole court landscape changes back to established knowledge attachment and those sorts of things. And so the court systems globally hang in the balance of the decision of this administrative law judge, as well as the admissibility of AI evidence. And so, as well as getting the interesting cross-examination of parental alienation syndrome as represented by Doctors Berent and Lorandos, its two most prominent advocates, and established knowledge, DSM-5 in attachment and complex trauma as represented by Dr. Childress. So if you're not paying attention, shame on you. And if you're not getting media to pay attention, shame on you. This is going to be quite the interesting event. So I will get a 15-minute opening argument, and then the state will present their case on Monday all day and Tuesday morning. I will present my defense starting Tuesday afternoon and Wednesday. And here's basically the schedule we're looking at. The state indicates the following schedule for the prosecution. So we'll both get 15-minute opening statements. Then on Monday morning, they're going to present the two analysts who acquired the information about the posts or whatever. And so then I'll cross-examine them. I don't expect much cross-examination of them. That's not where the focus of this case lies. Then Monday afternoon, the state will present the direct examinations of Doctors Berent and Lorandos, and that's when I get to cross-examine them. And that's going to be the central focus of the defense case. That we'll see what happens. But that's going to be the interesting cross-examination of those two. Then Tuesday morning, they present their expert, which again, I don't think is going to be particularly eventful. They'll say, by applying the collegiality standards, I was in violation of collegiality standards. That's what they will allege. But that's not the defense. The defense is that, let me talk about that for a second. So the defense, I'm saying there's a conflict in the ethics code regarding my obligations. There's a collegiality standard, play nice in the sandbox, and there's the protective standards of 1.04 and 1.05 that are triggered by ethical violations. And so I'm arguing that when there's a conflict in the ethics code, principle A is the one that provides guidance on how to resolve that. And what principle A requires is that we avoid or minimize harm. So then it becomes a comparison between the state's case that I'm harming professional reputations and the defense case that the ethical violations 2.04 and 2.01 and cascading out to 9.01 and 3.04 are about children and parents in the family courts. And so the which one minimizes harm? If I maintain collegiality and sacrifice the children and parents, or do I protect the children and parents and sacrifice collegiality? And so that's going to be the crux of the case. It's not about parental alienation necessarily. It's about ethical standards and the conflict of ethical standards, but it is about parental alienation because 1.04 and 1.05 are only triggered by ethical violations. So then it becomes about 2.01 and 2.04 and 3.04, avoiding harm. So it's going to be such an interesting kind of legal case regarding that. And it's going to be interesting. Then with the defense is going to start on Tuesday afternoon. And Tuesday afternoon, I'm still working out the schedule, but I think this is going to work. Tuesday afternoon, I'd like to present Dorsey Pruder and Peter Knudsen regarding their eyewitness testimony on things. Now, Dorsey, I'm going to hopefully, maybe over objections, but I'm going to hopefully expand her a little bit to talk about the situation in the family courts, because she has direct experience at the point where the child is being separated from the pathological abusive allied parent and being transferred to the targeted parent. She has direct experience with these children and families that she can speak to and speak to the harm that's being caused by this parental alienation idea in the family courts and the institutional capture involved, because she has direct experience of that. Plus, she has a whole research project, custody resolution method, that will ultimately be replaced by AI. So that custody resolution method has implications for when I try to introduce the AI augmented evidence, because AI can do document review more efficiently, more neutrally, and at a lower cost than what she's currently doing with human data taggers and stuff. And so it's just going to be such an interesting case. And then, so that's Tuesday afternoon. Then they'll get cross-examined. But I'm not thinking they're going to get much cross-examination. I don't know. Then on Wednesday, that's when I start my testimony and cross-examination. And so that will be another interesting day. So I'll start with my direct examination of myself, starting with my expertise and background, and then moving through my 1.04, 1.05 protective actions that mostly are on the line of Drs. Berent and Lorandos, but also the situation of the institutional capture and institutional trauma, which is when I'll seek to introduce that evidence, because Standard 1.05 says I must required take further action appropriate to the situation. So that requires what's appropriate to the situation, and that's the institutional capture and institutional betrayal trauma and the forensic custody evaluators that have captured the field. And it's within that situation that these self-proclaimed experts in pseudoscience are allowed to operate without consequence, without oversight, without review, without any sort of ethical standards being applied to the practice, because it's existing within a separate domain. That's the isolation, the separate domain of forensic custody evaluations, which I'll have explained. What I'm going to do is use the expert that they present, who's a forensic, not a custody evaluator, I don't think, but a forensic psychologist in general practice out there. And I'll use that testimony in my cross to explain to the court the difference between forensic custody evaluations and clinical psychology. They're two totally different kinds of activities by psychologists. So I'll have that explained. And then when it gets to my testimony, I'll talk about how that represents institutional capture. And I'll try to introduce evidence that my standard, that my 1.04 and 1.05 standards continue because of that. And so I'll reference the 2025 course and the 6 custody evaluators and the violations there. I won't go very deep into that, but I'll see if I can just introduce the evidence consistent with my obligations under 1.04, 1.05, and duty to protect, which is the entire defense. And so it's relevant. It's a consistency of my actions across time. So we'll see what happens off of that. And then I get cross-examined by the state. So that'll also be interesting. So that's when they get to bring up all the stuff and see if they can impeach me and do their thing relative to my testimony. So Wednesday should be very interesting. And that's when I'll try to introduce the AI, augmented analysis. And so we'll have arguments about that as well. And then let's see, then we'll do the closing arguments. And the opening statements are to frame what's going to be happening in the situation, so it's not argumentative. It's the closing arguments where I can take all the evidence that's presented and kind of connect all the dots and put it all together. So that will be interesting, and especially if I can introduce the evidence on the institutional betrayal trauma and the evidence regarding the capture by the forensic custody evaluators who are conducting this experiment on human subjects without IRB approval. If I can introduce that, and I suspect I can, then I'll be able to incorporate that into my closing arguments. But I think most importantly is that I've been carrying a duty to protect, clinical duty to protect regarding abuse pathology, and a standard 1.05 mandatory obligation related to ethical violations. And both of those I've been carrying for 15 years without a location to discharge them. And so in the closing arguments, I will hopefully, because of all the previous evidence, have the opportunity to discharge my duty to protect to the appropriate institutional authorities. And I will use that opportunity to do that and then free myself. I've told the licensing boards what's going on in the family courts, and what they choose to do about it is now their obligation, no longer my obligation. So then I can hopefully return to the family courts and focus on the family courts and bring AI analysis into the court system. And so we're going to see what happens. It's going to be a historic kind of event going forward. The 3-day hearing is open to the public. There is no recording permitted, so you can't do this. This is a courtroom, so you have to think that you're in a courtroom, so behave yourself. A court reporter will be present, and there will be a transcript available. The administrative law judge noted that people had been requesting the Zoom link to observe, so they're taking notice that the public is taking notice. That's a good thing. So you can find that Zoom link, ask around. And if you hear about it, I'll post it up. But I'm more focused on my case. You guys can figure that out. What's the Zoom link? Get it out to everybody and get it out to the media, and you can figure that out. The administrative law judge noted that that people had been asking, and I want you to remember, you're in a courtroom. So turn off your camera and mute yourself. That was another thing that the administrative law judge indicated. So you can request a link, turn off your camera, no recording. I recommend you do everything in your power to have media in attendance, because this should be very interesting for them on several issues. The family courts, the drama of Dr. Childress cross-examining Doctors Berent and Lorandos will be very interesting to observe, as well as the institutional trauma capture and institutional betrayal trauma will be a very interesting aspect of the testimony on Wednesday, as well as AI in psychology or AI in the court system, which will potentially be argued on Wednesday. And so there's a lot of things that the media would be very interested in. And the state legislating aides would also likely be interested relative to the function of the licensing boards to protect the industry versus to protect the citizens. And so we'll see how much evidence I can get in versus objections from the state. We'll see about that. So that will be interesting. And then, hey, Dr. Childress gets to cross-examine Doctors Berent and Lorandos. And you're going to want to watch that. And there will be a transcript on that. So, yeah, historic case, potentially landmark case, and potentially moving forward into various other legislative review, potentially a class action, because the moment the licensing boards stop forensic custody evaluations because they're dangerous, harmful to children, lack scientific and legal value, an experiment being conducted on human subjects without IRB approval, as soon as they say, wait a minute, we should probably take a look at this practice of forensic custody evaluations and the evaluators, then they admit that they've been experimenting on human subjects for the last 40 years, which they have, without IRB approval, which is a problem, in violation of all three principles of the Belmont Report, which is a big problem. So, and that's the institutional betrayal trauma. We now have adult children and their parents that have been traumatized by the failure of the protective systems to protect them. And so it's not their fault. It's not the now adult child's fault that happened. It's not even the allied parents' fault. They're pathological. That's trauma in them being transmitted. So they're just doing what they kind of have to do because of their own trauma histories. And then it's not the targeted parents' fault. They did nothing wrong. They're a normal range parent, love their kids. So nobody did anything wrong in this situation. It was the failure of the professional psychology services that they received. It was a failure of the institutions that were supposed to protect them, the APA and the licensing boards. And then these forensic custody evaluators got the platform of the AFCC to promote themselves, just like the PAS experts got the platform of Dr. Bernays' parental alienation study group to promote themselves. And so it's all about self-promotion in the family courts. It's not about science. It's not about professional diagnosis or treatment. It's whoever can sell themselves to the court. And that's a significant problem when the pathology is child abuse. So with that, I'm going to head on to the rest of my day of preparing for this hearing to come. There's going to be a little flurry of activity on Monday when my exhibits all kind of lined up and set away. And then I get to prepare over Christmas and the weekend for the actual hearing. And then we start. We'll see what happens. Talk to you later. Bye-bye.